This is FBG.Live. From touchdowns and concerts to weddings and Christmas parades. Live video production right here in Fredericksburg, Texas. Live, local, here for you. FBG.Live, capturing your moment for generations to enjoy.
Lord, we don't look for wisdom just in our own heart or mind or soul, but we look to you, Lord, because you are the one that gives us truth, gives us true wisdom. And so we need this for our commissioners today and the court and everyone participating. Lord, we look to you, and we know this is one nation under God and one county under God. And so we lift all the proceedings today up to you. In Christ's name. Amen. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Under the Texas flag, I pledge allegiance to thee, Texas, one state, under God, one and indivisible.
Okay, it's 9:04 a.m. on March the 10th, 2026. This is a regular meeting of Gillespie County Commissioners Court. We're going to call the meeting to order. All members of the Commissioners Court are present this morning. We'll move to item number 3, which is a proclamation for Child Abuse Prevention Month. Do you want me to do the proclamation first, or did you want to do your introduction first?
Well, why don't we do that first? Well, I'm here good morning.
Good morning.
Good morning. I'm here for 3 or 4 different things. Number one, after many years, too many years, of being the chairman of the Child Welfare Board, I'm gone. I'm not going to be there anymore. No, I'm going to be on the board, but I'm no longer going to be the president. I finally convinced someone else to do it. And that's who is here today with me, Teresa Gabriel. She's been on the board for a year, but I made a decision after the summer, and she was willing to do a new strategic plan for us and do new bylaws for us that she could handle the board. So we're glad to have her aboard. Good. Oh,
Thank you.
Thank you. And the other thing I'm here is to ask permission to put the flags, windmills, around the courthouse again this year. This year there were 41 confirmed victims of child abuse in this county. That doesn't mean that there weren't many other children that received services, but those would be the children that were actually confirmed as being either abused or neglected. So, do you have any questions?
I have no questions. But I would like to thank you, Ms. Altas, for your years of service. You've done a great job, and you've brought a lot of light to this subject, so thank you very much
Thank
for
you.
all you've done.
And do you have the proclamation?
I do have the proclamation, so I will read that. That's the first item on the agenda that we're addressing, which is item number 3. It's a proclamation for Child Abuse Prevention Month. Whereas child abuse prevention is a community responsibility, and whereas communities thrive when they promote programs that benefit and protect children and their families, and whereas effective child abuse prevention programs succeed because of partnerships among government agencies, schools, religious organizations, law enforcement agencies, and the business community. And whereas It's Up to You, which is the title of a program, focuses on personal responsibility in making a difference in children's lives, and everyone in the community is encouraged to become more aware of child abuse prevention programs. Now therefore I, Daniel Jones, as Gillespie County Judge, proclaim the month of April 2025. We'll change that to 26, I think. Of April 2026 to be Child Abuse Prevention Month, and April 1st, 2026 is going to be Go Blue Day in Gillespie County. And we urge all citizens to work together to help reduce child abuse and neglect in our community. I'll go ahead and sign that.
Okay.
And then item number 4 was your request to place the pinwheels
Yes,
on the courthouse square. Did you want that to be the same location as
Yes,
last
as
year?
last year. And the other thing I should say is people wonder what they're about. And so we have written a little paragraph in it, and it's in at the librarians at the desk where you check out. And I think on one of the bulletin boards, they also have an explanation too as to what it is.
What's the time frame of that display?
Well, the 1st of April to the through the 30th. And we'll make sure they get down when they're supposed to.
We've seen some children pick them up and walk off with them.
That's
so.
okay, we don't care. Just,
Thank you.
thank you. Thank you.
Yeah, it's nice to meet you.
Yeah, oh, yeah, I will, okay, thank you.
I'm gonna stay for a while.
Okay, does anyone, we need a motion for item number 4.
I'll move we approve the request for the Gillespie County Child Service Board for a visual display of county property related to the Child Abuse Prevention Month.
There's a motion and a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. Item number 5 is receive and discuss updates on the Nebo Mountain fire.
All right. Good morning, everybody.
Good morning.
I am here to give just a brief summary on the Nebo fire that occurred a couple of weeks ago. I also have Chief Frapke here to make a statement and also provide information as well. And so on the 24th of February, we got a call into dispatch about a wildfire that started just on the west side of Willow City. The fire affected the entire area from Exxon Road, Homan Road, all the way to Legion Creek Road. As soon as we got there, we realized that it was very rocky terrain, hard to access, challenging. So we made a call for the Texas Forest Service, and we had planes out there pretty quickly to make air attack. We also had a task force from the county with all departments serving the initial response, and they worked the entire day until we had to start making decisions on where we were going to go from there. I think it was around 8 p.m. We had the acreage at about 500 acres, 5% containment, again, because it was in just a hard-to-access area. And at that time, we were in close conversations with the Texas Division of Emergency Management, the state emergency management agency, and it was recommended that we do a disaster declaration, mostly for the reason that we had so much aircraft. Also, at that time, we only had 5% containment. And so we really didn't know, based on the fire weather conditions for the rest of that period, what we were going to be faced with. We had crews remain from TFS overnight, watching the fire, making sure it didn't extend. And then we decided to activate the Emergency Operations Center on behalf of the county. We filled the Emergency Operations Center with fire department representation, the sheriff's office, AgriLife, county roads and commissioners, Public Information Officer Sean Dory, as well as the TDEM, Texas Division of Emergency Management, to manage that response. We did 2 days of Emergency Operations Center activation to support that, and we also applied for a federal FMAG reimbursement. During that first day, Emergency Management was able to send out alerts to everybody who was signed up in the affected area, letting them know about that. We also did quite a bit of press release, and we did social media awareness for staying out of the area, impacts, all of those things. We held a variety of city-county coordination calls, which also included state agencies, and we worked very closely with TDEM in the event that we were going to need to extend our operation. I am happy to report that we did not have any residential structures lost. We had 2 outbuildings lost. One was a very old cabin. Another one was a barn or a shed. We had 11 impacted landowners, and all of them have been reached out to by AgriLife with support for land recovery and fence rebuilding and things like that. The biggest impact we had from that fire was that one landowner had some grazing property adjacent to the fire that got a little bit of heat damage from the fire. It didn't burn, but it crisped it enough to where they needed supplemental feed, and we were able to work very closely with AgriLife to actually get feed from locals in the area until they were to have the rain, and the rain is projected to really help out the recovery of that field. And so that was completed last weekend. And then, other than that, we've been working closely with the state on reimbursement. I will say, unfortunately, we were denied the FMAG, which would have been from FEMA. The reason behind that is by the time we got it in, it was more than 10% containment. And so the federal government has a very strict rule on reimbursement and things like that at that time. And so there's still a possibility we could maybe get it, and so we're preparing for reimbursement. We're doing our tracking and documentation in case we can get that. I know TDM was kind of following up to see if they would make an exception, but at this time we did not get the FMAG. And then, just to wrap things up, we're going to be doing an after-action review in 2 weeks. So we'll be working on reviewing our response, taking a look at how all that went, and improving our county response plans from there. But with that, I want to make sure to give Chief Radke the opportunity to discuss, since he was one of the key incident commanders for the fire, also held unified command the entire incident.
Thank you, Ashley. Well, I don't know why we always have to have the fires in Willow City area, but there's rumors starting to fly around. But we just thank everybody that was there. I thank the county for the use of the equipment that saved us. We've been talking a lot. We were within this close of having another crabapple fire. If we wouldn't have had the manpower and the equipment there as quick as we did, we could have had a crabapple fire again, and we all know what happened there. So I thank everybody. I thank the sheriff's office, the court. Thank you very much. Everything is sort of back to normal. The country that burned is sort of green, and if we get some rain, it'll really be pretty. But other than that, we do what we do, and we thank all the out-of-town people that came. It helped us a lot. Have you all got any questions for me?
Thank you, Chief Radke. I mean, without you, I heard you're on the radio constantly, so I don't know how you do it. You take control and you run a good ship and is well organized, and we want to thank you for that. And Ashley as well in the ELC. Commissioner Weinheimer and I spent time with her up there, and it's amazing how well y'all are organized and how well y'all work together. So thank y'all for that, for our county people.
Well, it might sound organized, but I will tell you the first hour and a half or 2 hours is total chaos. But we got it. We got it. It's organized chaos, but we got it done, and I'm glad of it.
And it's amazing how quick all the other people responded.
Yes.
I mean,
yes.
It was a community again.
Yep.
It wasn't.
It is wonderful, I will tell you.
Thank you, Chief.
Do y'all have any other questions for me? Okay, thank you.
Thank you, Ashley. Chief, you have something else? You're good? Okay.
Okay, so item number 5 was for discussion only, no action. All right, we're going to move to item number 6, which is receive public comments regarding the Rogers Draw Battery Energy Storage Project and the Marshall Springs Solar and Battery Solar Complex and Battery Energy Storage Project in Gillespie County. Are we at capacity, or do we have everybody in here that wants to speak on this item or hear this item? Are there people being held out in the hall? Is there sheriff's office personnel over there?
They're asking Judge right now. We're asking him.
Okay.
Judge, there are individuals in the hallway, but they do not want to.
All right, let's see. We have 1, 2, 6, 8. All right, we have eight individuals that have signed up to speak on item number 6, and I believe we have 2 for item number 23. So we'll do item number 6 now, and then we'll do 23 before we go into executive session. What did I say, 8?
Yeah, 8 total.
All right, Jay, you're number 1. Oh, you're on top of the stack.
Morning, Judge.
Morning.
Commissioners. So, I'm going to ask a couple questions in this, but they're rhetorical questions. And I'll conclude with a final question that I will leave you all to deliberate on when I walk away. Do you understand the term public servant? You are not the king and princes of Gillespie County. You serve us, not the other way around. You would be remiss not to remind yourselves of that every once in a while in the way that you deal with us. We pay your checks, and you answer to us. And I say that with all due respect. You should particularly remind yourselves of that when you're using pseudonyms, fake names, and family proxies to attack private citizens on social media. Speaking of answering to people and holding accountability, I cannot pretend to be privy to how each of you treats your wives at home. I can only imagine that if I were treating my wife at home and she were upset or angry about something, that being dismissive of her would be a very quick way to anger her. Dismissing those who are attempting to hold us accountable, can only serve to further anger and upset them. I would never dismiss my wife, and I would imagine that none of you would either, from sharing their concerns, because at the very least, even if you do not agree with them, it could at least diffuse the situation or potentially make them feel a little bit better about the situation at hand. I would hope that you would not just dismiss them, because in my eyes, I could see that as being incredibly disrespectful. Just like when you deliberate openly on a hot mic as to whether or not you will be dismissive of 30 Gillespie County citizens in this very room. When I sat here and listened to Don Weinheimer on open mic say, and I quote, "I don't see any reason to hear them." Now, of course, not allowing public comment or discussion on the Ampere project in the last commissioner's hearing didn't really matter because there was no new information to discuss anyway, right? Information such as the county judge and county engineer meeting with Marshall Springs developer Ampere informally, quote unquote, per the emails, and quietly just 6 days prior to that commissioner's hearing on Monday, February 18th, conveniently 2 weeks before the election. The meeting that you conveniently left transcripts and description of discussions out of the public information request that you provided to me yesterday. That public information request specifically requested all communications between county officials and Ampere. We were provided with emails, and I'm very grateful for that. But it was supposed to include all communications, including those held in discussion with Ampere in that meeting, which was held 5 days before that public information request was filed on February 23rd. Speaking of misconstruing statements, after refusing to allow public comment or discussion on Ampere in that commissioner's hearing, you decided to make your own public comment, Judge Jones, about Ampere yourself. You printed out a headline of a post regarding Ampere made on Fight Best Texas. This printout right here. Does that look familiar? Fight Best Texas is a nonprofit formed by private citizens here in Gillespie County that has dumped almost $100,000 into public awareness and legal fees to do your job for you when you didn't do it. We have another $150,000 legal tab already on deck because you didn't do anything about the battery facilities until you were forced to by these citizens. But did you even bother to read the first line of this article that this headline was attached to? I'll read it for you. It's in big, bold letters right below that headline. It says, layman's terms, Judge Daniel Jones sent a letter to the Texas Attorney General asking for attention or for affirmation to deny releasing requested Freedom of Information public records due to existing litigation with Peregrine, and now citing, quote, from your letter, pending and anticipated litigation. Right here in your own letter, directly in reference to Ampere. Now, in that commissioner's hearing, not only did you talk about Ampere, which you disallowed citizens from speaking about because it wasn't on the agenda, maybe rightfully so, but by not looking at the very first line of the article, you purposely misconstrued the headline for political purpose. Then you specifically abused your position of power by, on video, once again, instructing the newspaper to do a write-up on your comments without the opportunity for public rebuttal by disallowing citizens from speaking on the topic. The newspaper then happily obliged you in writing a political hit piece, directly defaming myself, naming myself personally as a private citizen, and the Fight Best Texas nonprofit, both of which have specifically stated that we are not political entities, providing both of us with further protection from public defamation not appropriated to political figures or candidates such as yourselves. So in conclusion, I have a single question that I would like for you all to deliberate amongst yourselves. Will you or will you not be issuing a public apology to myself and Fight Best Texas for the defamation of my personal character as a private citizen, or will myself and my team be forced to seek out further appropriate action for the enforcement of your accountability? Thank you for your time.
Anybody want to respond to that? I've got comments. The only statement I made to the newspaper was the statement that was heard here, which was that I disputed the veracity of that one statement. There was no direction to the newspaper, had no other conversations with the newspaper beyond that statement that was made here publicly. You can, I'm sorry?
You said that they lied, that Jay lied, and that
No, I said that that statement was untrue. That's exactly what I said. You can watch the video.
100% false versus a lie?
It is a false statement, and it continues to be a false statement. There was additional statements made that said that this was the second time Gillespie County had been sued in 2 months. That was false too, which was related to the same headline that you're talking about.
Said potential.
Okay. You know, I don't care what you characterize FBG or FBT as. You can claim you're political, non-political. FBT did run a political ad in a newspaper about 4 weeks ago, so I think it's you're hard pressed to claim that you're completely apolitical. That was funded. I'm sorry?
What political ad did Fight Best Texas pay for? Please show me the exact article that
It's in the newspaper. Everybody saw it.
No, that was paid for by Bruce and Brendan Nichols, Fight Best
I'm not talking about that. I'm not talking about that. It was before that. Okay, well,
Please explain which
Show me the article.
I don't have the newspaper in front of me, but did anybody else see that?
And prove it.
Okay.
Do not make false statements unless you.
It's not a false
Show me the
statement.
receipts.
Truth is an absolute defense to defamation.
I guess then we're going to get to discuss that article.
Anybody else want to clarify anything before we move on? All right. Esther Schneider, you're next.
Good morning, everyone. I have more questions than anything. Judge Jones, when did the two best projects appear on the county's economic development plan?
Are you talking about the EDC?
Yes.
That would be something you need to ask the EDC. I mean, we're not, I know that there was some early references to that in 2023, I think I saw, but that's not our organization. That's a separate organization.
I understand, but the county does pay part of
I agree with
Mr.
that.
Lindbergh's
I agree with that.
salary.
Yes, ma'am.
So you're saying that you did not see this, or you say, can you just please clarify? When you got the report that these projects were on there?
When this, issue became, number one, as far as our, in our concern and the public's concern, I started looking through everything I could find to find out when we had any communications, and I found some old minutes. I think they were like minutes or the report that Tim Lindbergh does, and there was some reference in there to a project, and I don't remember the exact date. I want to say it was like early 23. It was a while ago, and I don't remember if that was for Harper or for the Marshall Springs project.
Okay. According to the FOIA documents received yesterday, it is true that Melissa Eckert had contact with Ampere as early as April 5th of 2024, at least 6 months before she was in contact with Peregrine. Did you share that information when you had your meeting with Ampere and the citizens of Marshall Springs on the 18th? I have your email. But that wasn't, the question wasn't directed to you. It was directed to Judge Jones.
The meeting on February 18th was only myself and Melissa Eckert and 3 individuals from Ampere. There was no public in that meeting,
There was no public and no people in that meeting?
other than the 3 people from Ampere.
Okay. Just like Peregrine, the county has had prior knowledge and failed to inform the county residents. My FOIA requesting internal communications between Ampere and the county officials, including county engineer Melissa Eckert, was purposely sidelined so that the residents would not know until after the election. I have a copy of all of that communication, which has been sent out to a lot of people, that gives the timeline. And you stated on the February 24th meeting that there was no litigation. But yet, again, like Mr. Choquette stated, you denied my my FOIA based on the fact that you sent a letter of requesting an opinion from the AG. I find it interesting that you said, again, on the 24th, there is no litigation, yet you use that letter to deny me that information, and yet we have on executive session today, Ampere, and it specifically says consultation with legal counsel regarding contemplated or pending litigation involving the following items and take appropriate action related to the same. Number 1 is Ampere and Peregrine. So why is it an executive session if there is no litigation and there is no anticipated litigation? Why have you denied my FOIA?
Pending litigation is different than anticipated or contemplating. Pending means it's in place, it means it's ongoing. Anticipated or contemplated means it may be, it may be imminent based on the facts and circumstances. The language on the agenda comes from the Open Meetings Act language that allows for an executive session. The language in my brief to the AG's office comes from the AG's language from the Public Information Act section that talks about pending or anticipated.
That was not the question.
Well, what was the question then?
You denied my FOIA and failed to provide the communications internally that I now have that you sent to someone else's FOIA.
That's not the same information that was withheld.
Well, okay then. What was the information that was withheld?
It's at the Attorney General's office. You have remedies with the AG's office if you don't like the withholding brief that was sent.
So, again, you supplied information to Mr. Choquette yesterday in his FOIA, and this is emails. These are emails from Melissa Eckert between Jeffrey Alvarez and several other individuals, and it does talk about things that would be harmful to the county, and our claim that the county has not been truthful with the citizens about the discussions with Ampere, and specifically talking about what is construction for the project. And again, there's a lot of emails here. I intend to make a complaint against the county because you've denied the FOIA. And you've given no good reason why you have denied that.
Again, there's remedies with the AG's office for you to submit your own brief, and you can request them to make a determination.
We are going to do that, but I want people in this room to understand
But
the
you're
games.
you're alleging that the withholding was unlawful or somehow wasn't supported by the
No,
law.
I'm asking the
That's-
question, why did you do it?
It's in the brief. It's in the legal reasoning and the rationale.
You're also putting Ampere and Peregrine on your executive session, which according to Robert's rules is reserved for litigation. Is that correct?
It's reserved for contemplated or pending litigation or for matters that you need to discuss with attorney that's protected by attorney-client privilege. That's what 551071
So,
protects.
again, it doesn't look very transparent, and that's the point, is that we've asked for this information, and you've denied it, yet you turned around and gave the same information to someone else. So, asking the question, okay? I have another... Actually, that concludes my questions on this. Thank you.
Thank you. Mr. Robeck, Robert?
Commissioners, Judge,
Yes, sir. Go ahead.
my name's Bob Roebuck, citizen of the county. I have a couple of questions, and the first one is, this is the second time we visited the Commissioner's Court that handicap parking listed publicly as handicap parking has had a delivery truck in it. We've got enough law enforcement here to tackle a January 6th attack of Washington, D.C., yet they continue to use the spots. Why? I think that could be asked of any of the law enforcement, why no tickets have been written, or...
I think it's a fair question. Do you
Okay.
know, was it one spot or multiple spots? Do you
No,
recall?
just one spot.
Okay. Because there is one spot that's like a loading, sort of temporary parking
Yeah,
space.
well,
but
you know,
that's interfering with the...
If they've got that many deliveries, I think the delivery should be... Thank you. I congratulate the county commissioners and law enforcement for prompt action. Thank you very much.
We'll look at that. Maybe we need to reconfigure that parking lot or something
Yeah,
to address that.
you know, it's not a big thing, but it's irritating.
It is a big thing because we do have handicap people.
We do, and I want to point that out. My wife is 100% disabled. Jay, obviously, and I'm sure other people in here. But in any case, it's not a big deal, and I really, really can't thank you enough for the action. Could we see some action as rapidly as that with the financial situation? I'd like to have some updates on, I can't believe we can't get our checkbooks in order. And that's the end of my comments. Thank you very much.
Thank you. Mrs. Roebeck? Sorry, is it Beck or Bach? I didn't. Bach.
Good morning.
Morning.
Just some generalized bitching. We are the people of Gillespie County, and we deserve the truth. While the Commissioner's Court has taken the time to run for re-election, we have had to sustain several unfavorable comments and accusations directed at those of us who have the most at stake. We've been muted from speaking at Commissioner's Court. We've been subject to insults. The judge even accused me and others of subterfuge. We'll talk. Not going to ask for an apology because I don't think I'm going to get one. Meanwhile, Marshall Springs continues on an uncertain path just over a mile from my home. In 5 days, thank you, Chief, we will see the 1-year anniversary of the crabapple fire, the same fire that did massive damage to my ranch and home. We sustained approximately $500,000 worth of damage to my small house and 26-acre ranch. We only received about a third of that from the insurance company. We are still digging out, and there is much to do. 1 year ago, my husband and I were unaware that an even larger threat was further endangering our lives and home, Marshall Springs. Because we were not informed by our local leaders. Had we been informed, we may have made other financial and living arrangements at the time, instead of trying to repair and move on with our lives in our ranch. We, the people of Gillespie County, deserve better than this. We deserve more from our local leaders. We deserve the truth. We deserve to be heard, and we deserve to have our elected officials fight on our behalf. Thank you, gentlemen.
Tom Schneider? I'm sorry, I can't read the last name. The first name looks like Stefan.
Masonko.
Sorry, what was it, sir?
It's Stefan Masonko.
Masonko?
It's a Slovak name, Eastern Europe. Some people thought we were Japanese, no joke, until they saw us in person. You're not? No. As far as I know, I am not. Good morning. This is my first time speaking, but I am a resident and a homeowner here in Fredericksburg with my wife and my 2 young children, which is why I'm here. Because anybody who has children and a legacy of anything that we care about, it's about protecting them. And that's what's made me drive into my topic, which I imagine is, well, it's emotional for me because I think about danger. So, as AHJ, I think you have all the authority to address what's in here, what I'm going to be talking about today, which is about cybersecurity. And it's not something you can wait to talk about for ERCOT or for some other party. You've already talked about in prior meetings about having outside counsel, outside experts. And my expectation is because you care about it, and you've said on record, you care about the safety of both from a fire. We just heard just a little bit ago about a fire that could have been another crabapple. We're just a year away from crabapple. We know the dangers of what these pose, and we don't need to add anything that's going to add to that. So let's get into the details. I promise I try not to bore people, but my research gets into the technology that we're looking at here for both Marshall Springs and Harper, which has to do with the inverter technology that's there. Now, for those like myself who are not as well versed in what that technology is, the inverter is the technology that converts the energy from the battery or the solar panel so that it can go to ERCOT. It goes from direct current to alternating current. And we don't need to know a lot about the engineering behind that to know that that has to happen. And this inverter, what it basically does is it takes that direct current, cuts it into little pieces, and sends it, and cleans it up and sends it along its way. Okay, that's really what you have to know. It's important, though, to know that there's a couple of components in those inverters. One is the one that's actually chopping up the energy. One is that's cleaning it up. The transmission, the control that's going to control those two mechanisms, and then something that's going to communicate with the inverter. All of those, as I will show in a moment, all of those can be compromised and have been compromised in our state already, and in other parts of this country, by companies that are not doing their job. And we know that there's bad actors that want to use these vulnerabilities to actually attack our grid. So let's actually get into the fact that these people, and we'll talk specifically about Ampere, which is why this is on the agenda, but we'll talk about these companies and the fact that they're not doing their job. In my research, what I found was several articles from research papers from the North American Electrical Reliability Corporation, going back to 2022, 2023, and the latest being 2025. This one was a report done on inverter failure that led to 1,700 megawatts that dropped out of the grid at the time when the power was actually needed. Again, because an inverter had failed. Now, this is just about electricity going offline. All of us kind of think here, oh, what's the big deal? It just goes offline. Well, it gets worse. This one was a report also from the same group talking about the fact that these inverters are not being installed. Actually, no, this report was about the fact that the manufacturers of the inverters were not actually truthful and honest about the software and the hardware that was in them. Therefore, that the companies that were installing them didn't actually know what they were putting in. This caused more failures. And this one is the most harmful. This is one that's talking about the fact that the settings in these are not being adhered to, and they can cause what's called harmonic resonance. Now, I know that sounds, again, language that most of us don't know about. You can think of it like an opera singer, right? It's able to push the vocals and the beautiful sound all the way to the back of the room where they can crack glass. Harmonic resonance does a vibration in your wiring that can destroy your downstream power grid, okay? That could cause a fire. This is a known issue. This isn't something that is, James Bond-like theoretical. This is actual stuff that is being known. Now, how do we know it's known? Well, we've got multiple people that are talking about it. This is a report called Cyber-Induced Harmonic Instability of Inverter-Based Renewable. I know, lots of language. What it's basically saying is exactly what I just said, is that you can use a cyber attack on the inverter to then create an attack further down on the grid. So it's not just about turning these off at a time of need. It's actually looking to destroy the sub-transformers like what you'd have at Crabapple or in Harper or wherever these are connected. So the story right now is that we have several instances that are already documented. First one in Odessa, so in Texas, where the people that are installing these technologies are installing them incorrectly. They don't actually know what they're installing, and they certainly aren't testing them. So in the best case scenario, you have people that don't really know what they're doing installing these things. But it doesn't stop there. It actually gets worse. Because we talk a lot about the threats from adversaries, from China. This is a report from 2024. PRC state-sponsored actors compromise and maintain persistent access to U.S. critical infrastructure. And I quote, "The People's Republic of China, the PRC, state-sponsored cyber actors are seeking to pre-position themselves on IT networks for disruptive or destructive cyber attacks against U.S. critical infrastructure. The first group that they note here is the Department of Energy." Among many things in this long report that were interesting, the author of the report noted that the group, the state-sponsored group called Volt Typhoon, which, kudos, that is a great name, they maintain access and footholds within some victim IT environments for at least 5 years. So what that means is that this group is in charge of trying to find weak spots in any part of the grid, and they're going to sit there lying in wait until the appropriate time. And they're very good at their job, okay? They're looking for inverters. They're looking for anything that's going to be connected to the grid that provides some kind of security hole. And again, how do I know that this is the case? Well, we've got loads of documentation, but this article from 2025 talks about the fact that these companies, which are creating the inverters or the batteries or both, from China, had rogue radios that were installed in these devices. These were not part of any of the materials list, And I quote from this article, over the past, the first one, this was found by U.S. experts who stripped down equipment hooked up to the grid. This equipment hadn't been pre-tested. It was already connected to the grid. They stripped down the equipment hooked up to the grid to check for security issues. They found including cellular radios, which would bypass any kind of security measures. Which leads us to exactly what they could do, which is what we call this harmonic attack, which is that the fact that you have to have all of your hardware, all of your software running in harmony so you're not creating any disturbances going into ERCOT, anything going into the grid. So the reason that this came to my attention is that everything we've been talking about here from a security or from a floodplain perspective, from a fire perspective, gets a lot of attention. It absolutely needs to be. But when I read all this, and then I combine it with what I understand, this is a printout. This is what I understand from Ampere, which I imagine is no different from any company doing Harper. And I just showed you evidence that these people that are installing these devices, they don't take any care, and it leads to shutdowns and could lead to cyber attacks. But this is from the meeting with FBG Solar Team, met with them on February 18th. This is from a post on Facebook. Yeah, I'm sorry? Same day. Okay. Same day we're talking about. Loads of information. The point I saw here, no information available on where the batteries will come from or where the system will be monitored from. Now, here's what I see, right? My background, I've got a background in a lot of different consulting, but I did internal audit for a long period of time, working at some of the biggest companies, General Motors, other type of large Fortune 500. You have to have your entire area mapped out, and you have to understand where your controls are across the board. What I see is that when I look at these reports, companies are given access to the grid and they don't test their software. They don't even know what's in their software. And they get certifications from somewhere in another jurisdiction that says, oh, it's being done correctly. But we know it isn't, and it fails. We know, because the US government is telling us, that they're looking for attacks. And we know exactly how those attacks may happen. And these are the attacks that we know about. This is the existing attack surface. This, well, I'm done showing articles because I think I've probably given enough. The point is, this is a serious issue. And also, I don't expect anybody in this room to be an expert on it. Okay? The electrical engineers that have expertise in this can look into it. The cyber security people that need to look into it. We need people that actually know how to look at the materials, look at the setup, look at the software, and ask the right questions. So my first question is, will you guys commit to having those experts review any and all plans that are submitted? That goes well beyond. And this is all, I mean, again, this could cause a fire. They could destroy these substations. This is within your remit. So that's my first question.
I'll speak for myself, and I think that a lot of what has become apparent when talking about these types of developments is that there are lots of areas of expertise that can be impacted, and so like the issue you're talking about, I would have no issue with retaining and utilizing experts to help review the parts of any submittals that would be applicable, I guess, to that expert. I mean that's. I think that our sort of mindset on this is that because of the complexity of these developments and the submissions that we intend to get, that outside expert expertise is going to be required, to review all of them. We're not intending to do any of that stuff in-house.
Fantastic.
Except for very basic, the routine stuff that, maybe right-of-way permit or something like that we would do internally. But these types of issues. Now, where we find somebody like that, and if you're aware of, that's one of our issues is trying to find these experts because this is sort of a new technology. But
thankfully, we live in a great state with a lot of great people. They're not always local. They can be in different parts of the state, but certainly we can find them, and I can look and find some that I think are good. And that actually leads to my last part here, because it's not all doom and gloom. You have the power to be asking these questions, and you're doing it. You need to do it now before any earth is moved, before they even talk about moving forward. Because I can see from their response, again, going back to what I saw from the 18th, they think they're just going to continue to push this forward. This needs to be part of the planning process. They need to have all of that information mapped out. Okay. So what are things that you can be talking to with a security expert about or electrical engineer about, questions that you should be asking? Well, I have about 5 listed here. One of them would be the hardware bill of materials, the entire list. Not a black box. We can't trust these people. I'm sure they can trust themselves. And I looked at by the way, I looked at the website for the company, Ampere. It's very clearly, they're going to outsource all of this stuff, just like all these companies do.
And then they're going to claim bankruptcy once they get it done and
Yep.
move on, and then we're stuck with that.
And they simply, they don't care enough. So, okay. Something else I think that we need to have, that we need to ask for is a rogue radio sweep. This goes exactly to the point that they could have parts of the device that are not intended to be there, that are not actually part of the bills of material. Someone needs to be able to actually audit that, just like they did in that Reuters, before anything is installed. And ERCOT, you may hear, oh, that's ERCOT's responsibility. The fire is our responsibility. If any of this stuff goes off because of what they did, it's this responsibility. So we ask for that. Frankly, I think we find the people that do the audit, if this ever gets down that way, and they pay us. There's no way I would ever allow them to run their own audit. If they had, they would have caught all the stuff that's already connected to the grid. A harmonic resonance test. This is where they're actually looking at the impact of anything going from the inverter all the way down to the substation. Again, these are things that add cost to the timeline and development that they're not necessarily going to want to do. Or they're going to want to say, well, we've got a certification for it. That is not good enough. There's something called grid forming versus grid following. This has to do with how the inverter actually maps to it knows how to turn on and turn off at the appropriate times. Again, this is above my pay grade, but if I can research it, they sure as hell better be able to respond to it. And then there's a few others having to do with what is already part of the Lone Star Act, what they're requesting, such as indemnity bond, proof of that. That act has been strengthened. I think it has a long way to go to actually protect us, because that's what. Again, this is where this is falling. We can't rely on them, because if you look at them, they're talking about indemnity of $1 million for claims. This is an $800 to $900 million project. I think that's negligible on scale. So anyways, thank you for the time. I appreciate you listening here.
Shed a little bit of light on the Lone Star Act.
Yeah, sorry. Good. I've done a lot of research here. I'm not as familiar, but thanks for putting me on the spot. The Lone Star Infrastructure Act, as I understand it, was put in place a couple of years ago, maybe a year and a half ago, to try and protect the Texas grid. The intention was to try and protect exactly against what is being discussed here, which is foreign actors having any ownership in any way of anything that would be connected to the grid. And I think the concern came up from people here all the way up to the state level saying, we have most of the, we all know, I mean, it's just known that 95%, 90% of the battery and the solar power technology comes from China. The software comes from China. The firmware comes from China. All of it is coming from China. Well, yeah, cattle, there's a couple different companies. And again, I'm not an expert in all of the, I think they call it Civil Fusion is the program in China, or the CCP, to actually run this. But the Lone Star Act is intended to try and protect our grid and protect our people. It's not just about losing power. It's about the devastation that could be caused here. But the most recent that I understand is that they've put in some penalties. So you're required to make an attestation to the state government and submit it that says we are not owned, or none of our subsidiaries are owned by a foreign entity, right? And there's a list of foreign entities.
There's only 20% that have actually complied.
And this is yes, thank you. But I just want to point this out. Only 20% have complied with something that is negligible at the edges. The stuff that we're talking about doing here, auditing the hardware, asking for the bill of materials, making sure that they actually do their job, making sure that they've actually tested any of the inverter software. I mean, one of these reports talked about the fact they had a null value that they didn't realize was in the code. How do you not test for this stuff? That's what anybody would know. I mean, you wouldn't take something in your pacemaker that would go in there, oh, well, we didn't understand what was wrong with the software. No, this is critical software. This isn't sitting in an ERP or accounting. So, it is our job to do this. The Lone Star Act sets out the intention, which is to protect our infrastructure. But right now, you guys are the cowboys that need to be coming in to ride and protect us because the state is slow to actually do what it's doing. And you need to move forward with the intention of that law. So hopefully I didn't put anybody to sleep. Thank you for the time. Thank you.
The next speaker is Jennifer. I'm sorry, I can't read the last name.
That's okay, I can't read my writing either.
Okay.
Sturgis.
Sturgis, okay. Jennifer Sturgis.
I'm Jennifer Sturgis. I live halfway between Harper and Fredericksburg. So I cheer for the Longhorns and I cheer for the Billies, and I'm thankful that they are in different categories and don't have to play each other, if I'm honest. I'd like to put this in perspective, at least in the perspective that I think is simple. It was simple for me. How many of you all have gone...
Ma'am, could you use the mic, please?
Sorry about that.
No, I'm sorry.
How many of y'all have gone on an airplane recently? Mr. Kramer and Mr. Gillespie, what was the first question that you were asked when you went to check your baggage? You got any lithium batteries? You were asked that question. I don't recall that question. That was 2 years ago July. That's okay. We cannot take a lithium battery the size of my pinky and put it in our checked baggage on an airplane. And there's a reason for that. They think it's going to have a chance to blow the airplane out of the sky. That's why we can't take a lithium battery on an airplane. So we have to take it from there. These are gigantic lithium batteries. As someone is recent, Mr. Stefan, is that? I can't pronounce his last name, pointed out, we're a community, and we have to stop fighting starting today, March 10, 2026, and start getting together as a community. Judge Jones is part of the community. Mr. Kramer is part of the community. Mr. Offers is part of the community. Ms. Schneider, who has worked her fanny off, is part of this community. And I'm going to be honest. When I first heard about the project, living halfway between Fredericksburg and Harper, I didn't give it much thought. I'm out, I'm riding my horse, I'm mowing on the road, want my yard to look nice. I didn't give it much thought. Y'all didn't give it much thought. But she gave it a bunch of thought. And she did a bunch of work. And like her or don't like her, want to spend time having lunch with her or not, she's owed a giant thank you because she brought your attention and my attention. She brought all of our attention to this issue, and it is dang important that we pay attention. So it's not about Ms. Schneider, and it's not about Jay, although he's a super fantastic speaker, and it's not about who's going to be our county judge. It's about we have to get together starting now and fight this as a community. So I saw something in the last week that, I don't want to be political, but I saw something in the last week that I've never seen or studied in my 59 years of life. Christian countries, the Jewish state of Israel, and Muslim countries have all gotten together to fight one common, real terrorist enemy, Iran. And if that can happen, then we ought to be able to get together in Gillespie County and fight a little old battery factory that wants to put batteries in our backyards. These people are owned, they're not owned by individuals. These are LLCs. And we heard about subsidiaries. Try to follow the LLCs sometime. LLC, Rogers Draw, is owned by another LLC, who's owned by another LLC, who's owned by another LLC. And we're all worried about the front end, and we should be because we have to stop it on the front end. Think about the back end for a moment. What happens when not even a fire is the most catastrophic thing that can happen, and then everybody files bankruptcy and we're all in litigation for the rest of our lives. But even if it becomes monetarily unsustainable, or the investors pull out of all these LLCs, or batteries aren't in vogue anymore and they're not green anymore, and we go find some other green thing that we all chase down the road, then what? What happens when they abandon these projects halfway through or while they're already connected to the grid? Then what? If they own the property and they walk away with bankruptcy and you can't follow the bankruptcies, the county's on the hook. And if anybody in this room, including all the commissioners and judge, think that the federal government is not going to make us clean this up, then we're crazy. They're going to make us clean it up on the back end when it all goes away. And I don't care who they are, and I don't care how responsible they say they are. You can't stop it once they file bankruptcy. And if you own leased land and you're leasing it to them and they file bankruptcy, guess what? You've got your land back, congratulations, and now you have a solar farm on it, and everyone is going to want that solar farm removed. Where are they going to put it? Where are they going to put all these old batteries that we all got from China that we don't, I call it getting it from Temu, or what's the other one? Shein. We've all accidentally bought something on the internet from Shein or Temu or something like it. Every single one of us has purchased something off the internet and opened up the envelope and looked at it and went, I just spent $60 on this. This is a 6-cent something or other. Most recently, I bought a clock for my husband for Christmas, a John Deere clock. It was garbage. And we can't assume that this isn't garbage on the inside because we don't know what's on the inside. And we might sound like conspiracy theorists, but really, every time there's a conspiracy theory, it turns out to be true in the end. So let's get together. Let's not fight. Let's not fight Ms. Schneider. Ms. Schneider, let's not fight Judge Jones. Let's not fight the commissioners. Let's be a group. If you need somebody to pull you together, to get you to eat lunch, to share a pizza, to form ideas, there's nothing better than bouncing out ideas off of everybody. And it affects all of us, because even if you don't believe that there'll be a fire, or you don't believe that the wind can carry all the way to Fredericksburg from Harper if there is a fire, even if you don't believe that, guess who might believe it? Tourists.
The insurance companies.
The insurance companies. We're a tourist industry in Fredericksburg, like it or not. A lot of people don't. I personally love running through town and seeing all the tourists enjoying themselves on the weekend. I love that. I would hate to see that go away because people are afraid to come to our community. I really would. So if I have anything to say, it's work with Jay. Jay, work with Judge Jones. Ms. Schneider, work with Mr. Offers. Work with Mr. Kramer. Work with Mr. Jensky. Mr. Weinheim, work with Mr. Weinheim. Get together. We shouldn't be enemies. We have an enemy. We don't need to fight among ourselves. We need to get these stopped. And when we do, we're the heroes of Texas.
Thank you, Ms. Sturgis. Mr. Knightsky, there he is, okay.
Good luck following that one, Bruce.
Tough follow on this one, yeah. Good morning.
Good morning.
I'm requesting an update regarding the activities at the BEST sites. Now, you filed notices of violation 3 months ago. What has been received back from Peregrine Rogers Draw?
I think the only thing we have received is a request to meet. Is that accurate?
I can't speak on everything that's come in from discovery in the litigation that's going to our outside counsel, so I haven't looked at all of that myself, but there has been a repeated request to meet, offered by Peregrine at the invitation of Peregrine to meet with Judge Jones and myself, and I believe Melissa Eckert is also invited to that meeting. but at this time, the county has not accepted that.
Okay, so nothing has been received in 3 months. So they're in violation. Okay, so have you issued fines?
We have not. Does the TI address the standing work orders?
I believe that the agreement on entering and I'll have to go back to get the exact language because I don't want to misquote it.
No, I have it here. I've got the Rule 11.
Yes, I'll need to look at the Rule 11 because it's been a while since I've read that, but I believe that part of the agreement was that we would not move forward with those while the litigation is pending.
No, what Rule 11 says is that there will be no additional, but the ones that are existing are to be continued. I have a copy of Rule 11 right here. So no.
So the answer, I guess, is no to your question.
Is no, okay. So on the fire code, you issued the notice of violation under 1.16.1. It was in the fire code violation, okay? So under 1.16.4.2, and I will just read it, violations of the provisions of this code shall be punishable by a fine or imprisonment. The word shall for the lay people, shall in the fire code means mandatory. It means you have to. So because they are not in compliance, the violations of the provisions of this code, which we've established exist, shall be punishable by a fine or imprisonment. And so what you're telling me is you haven't issued a fine after 90 days, after 3 months. That puts you in violation of the code. And just for edification, the general advice...
Is there a limitations period on that?
No. General advice given to companies who are in violation of the code breaks it down into immediate and 30 days and 60 to 90 days. There is no advice given to companies to extend past 90 days, and that's only for an administrative violation. So those are cautionary, but again, the fines, they were already in violation at the time you issued the NOVs. And so the Commissioner's Court at this time, acting as the AHJ, is also in violation of the fire code. I would like to ask that I'm requesting that you post any updates that you receive from Peregrine. I would like you to post your decisions on going forward with fines and penalties. It does say imprisonment is a possibility under the code. And then I would... And then also, I would just ask that you would post us and keep us updated. It has been 3 months since the violations have been posted. Thank you.
All right. I think that's everyone that signed up to speak on item number 6. Okay, go ahead. Since you signed up, we'll give you back your 1 minute.
Really, I can't add anything to the technical statements that have been made. They've been very good, very thorough. But what I would, following up on Jennifer's comment, is suggest that you create a committee of both the Commissioner's Court and citizens who are knowledgeable on these issues that can get together on a regular basis and find out and make sure we are understanding of what the next steps are and find out what has been done, what can be done. I think that would be very protective for all of us. So I'd like you to consider that.
I think
We
Commissioner
have.
Olfers, yeah.
We're working on it with Olfers
Yeah.
for Marshall Springs.
Yeah.
There has been work done to try to put together a committee. I think that, going back to Ms. Surgis's comment about working together, I mean, I think that there is some friction between the Harper, I'll call it the Harper group and the Marshall Springs group, and so I think we need to work to get some participation, maybe more cooperation from the Marshall Springs group so that they're equally represented on that committee, but, well, I mean, I think that they've been reached out to, but, the sort of...
I'm sorry, what?
Mike Best is in both Harbor and Marshall Springs.
Yes, and
Yes, ma'am.
I've met with Mr. J and we've
Yeah,
met.
there's been invitations extended to, I guess, to some of the individuals that are consider themselves more associated with the other project. And so I think that's the big key right now is trying to get that.
We got one of them from the Marshall Springs team. One of them has confirmed. He's just waiting. He's got a work engagement. He's just waiting to let us know whether or not that engagement is going to keep him from moving forward or not. But we do have participation from one of them.
Okay.
And with y'all's help, obviously, we would like to get, when we spoke with Mr. Olfers from day one, right, we said, hey, we want participation and equal representation for everybody involved with this. And so with y'all's help, we would love to try and get at least one more of them on board from that neighborhood or from that area. If you guys could help extend an olive branch, they don't always come easy for me, as we all know. So, but with y'all's help, we would really love to get one more person from over there on the team as well.
Yes.
Might I suggest we call it the Gillespie County, and we have Commissioner Olfers and Commissioner Cromer chair both of those because the projects are in your precincts.
I think the committee is still sort of in its infancy, but I think that's a good recommendation. I think your comment's well taken. We just want to respond that is, I think, in progress to try to get a committee together that will represent everybody's interests and hopefully bring some more cohesion to us working together as opposed to.
But I think it should be more of a community committee rather than us.
Right, yeah.
I mean, yes.
Yeah.
Well, but it is in your precincts.
Correct.
And
Yes, I'm
so-
happy to participate. But
I think we just don't want.
Commissioner Cromer?
Yes. A large base of technical expertise, and don't expect commissioners to have that expertise. Certainly think that.
Sounds good. Thank you. Okay, no other comments for item number 6, which was the public comments on the proposed best projects in the solar complex. And we've got a couple other presentations on the agenda. Let's move to, do we have people from CapCog or TxDOT here to do their presentation? Y'all need to set up any, did you want to do a digital?
We can actually set up in the systems.
I brought handouts.
Okay.
Sorry, it just hasn't worked out well in any of the other counties.
Okay. So we will move to item number 15. You want to take a brief recess, or do you want to? We can keep going. Okay. We'll take about, we're not going to officially take a recess, but we'll wait about a minute or two if anybody wants to leave the meeting. We got 4 or 5? I think it's in our packet also.
Do y'all need another copy?
We can share it. Or you have it sit here.
I'll get it. Hold on, Scoot. Dring, 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 dring. I like the way you jumped up and ran out the door, though. I cannot stand it.
ultimately, the solution is we need a loading and unloading zone.
Well, we've got an executive session, so we may make comments on that too.
That's what ultimately needs to happen. And then we required by.
Oh, good to see you, sir. Are you gone?
The county doesn't control that many, but the city has a lot. Word out already?
It's only good for a few more seconds.
You too.
Oh, no. Yeah.
This one's still hot, so be careful. I think it is.
Are you gonna do those presentations and then go to executive session, or? No, I agree. Regular business. Except for missing one.
Yeah. All right, we're going to reconvene the meeting. It's Commissioner Cromer around the corner. Commissioner Cromer? All right, we're going to start with item number 15, which is receive and discuss a presentation from representatives of TxDOT and CapCog for recommended projects in the Rural Transportation Improvement Plan. Is Cromer coming? Okay. All right. All right, go ahead, ma'am.
Good morning.
Good morning.
Thank you for having me to present this presentation. My name is Michelle Conkle, and I'm a planner with the Austin District of the Texas Department of Transportation. And today we're just presenting the projects, the draft list of projects for the rural TIP, which is a component of the statewide transportation improvement program. That's TxDOT's 4-year capital program for projects that will be built between the years 2027 and 2030. The rural TIP represents the counties of Mason, Llano, Gillespie, Blanco, and Lee. Rural TIP includes projects that are grouped. Those projects are usually maintenance in nature, as well as listed added capacity projects and regionally significant projects that are funded outside the MPO boundary in the counties that I just mentioned. The purpose of coming out and trying to obtain public input on the rural TIP is so that we can demonstrate regional agreement in the projects that were chosen for that TIP. So how does the rural TIP impact you? Well, it includes opportunities for you to provide input on major projects that are listed in your area, and these can include road expansion, sidewalks, bike lanes, pavement or repair and maintenance, new and improved signals, and turning lanes. Projects are selected for the rural TIP. They're identified and evaluated based on existing conditions, future needs, public input, and available funding. The Gillespie County projects, the draft list starts on page 9 of the presentation. And so currently in this draft list, we have a project on State Highway 16 from FM 2093 to the Kerr County line. It's an overlay project. We have a project on US 87 from 0.26 miles north of River Road to 0.26 miles south of River Road, and that's to construct paved shoulders and a left turn lane. On State Highway 16 from the Llano County line to north of RM 1323, that's also an overlay project. Project on State Highway 16 north of RM 1323 to US 290 is an overlay project. We have various overlay and road parking lot projects within Enchanted Rock State Park. We have a project on 290 from 0.73 miles east of Goman Lane to 0.4 miles west of Elgin Barrens Road, and that's also an overlay project. You will see two other projects, RM 965 and State Highway 16. When we originally took this presentation out, those projects were scheduled for 2030, the last year of the rural tip, and they have currently been moved to 2031. So they're still planned, they're just now currently outside the planning horizon. So this presentation, we will have a virtual public meeting in early April with this presentation. There will be a final list of projects and maps to go with all of that. We will be posting notice for that meeting in print, and also sending out invitations and letters to the county commission and county judges to let you know the date of that, so that you'll be able to see the final list. We'd certainly appreciate any comments that you have now at this time, and my contact information is on the very last slide. You can email me. We're trying to collect comments on this rural tip. I want to get my date right, through, I believe it's April 24th. So again, we'll have this presentation with maps for all of the projects on the final list, and also opportunity to comment on that through April 24th. If you have any questions on this, please feel free to reach out to me. If you have engineering questions, you can reach out to our area engineer, Joe Muck. But I really do appreciate your time this morning.
So are there projects in 2026 that are happening in our area?
I have not been asked that question yet. I'm sure that there are. If you email me, I can get you the projects. I saw some construction on my way here, so those projects would be included in our current tip step. So that's why they're not on this list. These are just projects that are going to be occurring between the years 2027 and 2030. Yes, sir.
How does Lee County become a part of our district? And it's like 5 counties away. I'm just curious.
Also never had a question like that. Lee County has just been a part of the Austin district for as long as I've worked at TxDOT. And that's been 34 years, so.
I'm going to try to give you an easier question.
Okay.
So the comments, what's the purpose of the comment? Does that drive priority of projects or change in scope of projects, or what does the input, what does that benefit to the person that's making the comment?
It certainly can. I mean, we're looking for comments that let us know that I would encourage that if there are projects on this list that you would like to comment on the scope, if there are projects that are not on this list that you think we need to pay special attention to or have our area engineer look at in terms of need, now would be the time to do that. There could be projects that are right outside of this window that you might see are a bigger need than the ones we have. I mean, there's all kinds of scenarios where absolutely your comments would affect the order of projects or the magnitude of projects or the need based on what you know here, since you live in this area.
Okay. Just for the public benefit, this draft of the presentation is in the Commissioner's Court packet. So if y'all want to go look at it online, you can do so to get an idea of what's being proposed. What was discussed today. Anything else from the commissioners?
I have nothing else. So thank you very much.
Thank you very much for your time.
Thank you.
Thank you all.
Okay, we're going to go back to item number 14, which is consider approval of a revised and updated master plan for the Gillespie County 1882 and the 1939 courthouses, and authorize submittal to the Texas Historical Commission of that master plan.
Thank you, Judge Jones and Commissioners. Good morning. My name is Whitney Kuh. I'm with Mustard Architects. We've had the privilege to work with the county now for just over a year. We've been working on a couple of projects with the county, but in conjunction with the other projects that we've been working on. Part of that has been updating the master plan that was started back in 2000 and submitted to the Texas Historical Commission. As part of that project, Wagner and Klein had created a master plan for this building, which is the 1939 courthouse, as well as the Pioneer Memorial Library, which is our 1882 courthouse. And they created a master plan for the preservation and planning strategies for both of these buildings. And we have taken the opportunity to update that master plan and presented that to the commissioners and the judge over the past few weeks in consideration as part of our larger process of consideration for other larger county projects that we're working on with them. So we are requesting approval today from the commissioners and the judge for submission of that master plan to the Texas Historical Commission this Friday for acceptance and update of that larger project. So as the master plan documents that we have provided have taken the original master plan created by Wagner and Klein, and we've utilized their documentation. They provided great service to our community, did a lot of historical research on the project, as well as the 2022 long-range master plan created by Banner, and as well as our documentation created over the past year. And we've taken all of that information and combined that into a single master plan for both of the two courthouse buildings that we have located on our county square into a single master plan document, which we'll be looking to submit. Our study includes both code and accessibility evaluations, departmental assessments and evaluations within the current courthouse facility, as well as environmental assessments of both of the buildings. Those include mold and asbestos assessments of the buildings, as well as structural, architectural, and what are called MEP assessments, mechanical, electrical, and plumbing evaluations of the current structures. We're also giving our recommendations for rehabilitation and preservation recommendations for both structures. That'll be given to the Texas Historical Commission in hopes of, in the future, requesting for a preservation and restoration grant for both of the buildings, should the commission and the judge approve those next steps with the buildings. So we've going to be starting with some basic information about our 1882 courthouse. The document does go into some of the history of the building, have an opportunity to have a building constructed in 1882 designed by Alfred Giles. It is one of his early works and he is a famous architect within Texas who did a lot of our county courthouses throughout Texas and a number of civic buildings, and it stood as a leader of our county government. It's actually our second courthouse, and it has stood as a unique testament to the architecture within our county and along our county square, and now serves as our public library. So this building did receive a significant restoration in 1967 and has seen some additional subsequent updates in more recent years, and we'll be continuing to look at opportunities for its improvements. During our conditions assessment of the 1882 courthouse, it does need MEP upgrades throughout the facility. The 2000 assessment did also indicate that it was due for mechanical, electrical, and plumbing updates at that time. It's now 26 years later, and all of those improvements that were done over time are still needed. But the county has done a fantastic job of continuing to preserve the architectural features of that building. We applaud the county for maintaining that building in the manner that it has. It is a testament of architecture in itself, and it's due for some TLC for sure, but it's also stood the testament of time, and it's got a lot of the original features still intact, and we're grateful that we have those opportunities to share with future generations and be able to showcase that building for what it can offer. So we do have some repairs that will need to be needed on that building, and we're showcasing that or outlining that for the Texas Historical Commission through this document as well, so that they can understand some of those items that are needed on that building. We, as part of this work as well, Candace, we did do an environmental study of this building, identifying just as we've all learned over time, the different materials that are no longer, what we used in the past are no longer safe for our inhabitants. Things like lead, asbestos-containing materials are all present throughout a lot of our historic materials. And so we'll have identified those throughout this building, and we'll be appropriately abating those through this process as needed, and making sure that we are appropriately ensuring that this building maintains a safe environment for future users. The key needs for the preservation and continued use of the 82 courthouse, are going to be primarily around ongoing and somewhat deferred maintenance. So as I mentioned, our electrical services, MEP services are kind of our primary concerns for that building, and then primarily the balconies. There's water infiltration that we need to deal with, and just general upkeep of our balcony spaces, and upgrading all of our utilities throughout the building. Overall, the building's in fantastic shape. We have no issues structurally or architecturally. Probably needs a good thorough cleaning on the outside, a little bit of repointing on the masonry, but again, we applaud the county for their efforts in maintaining the building architecture and its continued use. As we move into the building that we're in currently right now, which is our third county courthouse, this is our 1939 courthouse. It was designed by a more local architect, Edward Stein, in 1939. It is obviously a very different architectural style, but it does reflect a unique architectural style in its own right. And this building is, again, remains untouched, and I applaud from an architect's standpoint, appreciate all of our current county staff and previous county staff for letting the beauty of this architecture remain untouched, because that's not common to be able to walk through a building and have the footprint and the architectural details still be intact after almost 100 years. So we appreciate being able to walk through the building and still have all of the original pieces still be here. It does still have a lot of the original features, as you can see, terrazzo floors, the granite detailing, brick detailing. So as we walk through the inside of the building, we've got a lot of retrofits, as I'm sure everybody can see as they are throughout the building. The building is, again, going to be needing a full MEP upgrade, mechanical, electrical, plumbing, modernizations, meeting the current needs of the county government, as well as the district courtrooms and county courtrooms, ensuring that we can serve the public and the community through its needs and in future generations. So that's going to be the ways that our primary goals as we look into potential restorations of the building, as well as just ensuring that we can address any ongoing maintenance throughout the building. It is well loved, it's served its purpose, and is now time to address any items that need to be evaluated. From an architectural and structural standpoint, the building's in fantastic shape. There's nothing structurally or integrally wrong with the building. You guys have done a fantastic job, again, maintaining and overseeing being good stewards of this building. So now it's just time to bring all of our utilities up to date, and we appreciate the work that you guys have done on this building. So environmental study, again, we've got a lot of materials that are no longer allowed to be used, found in this building as well. Lead, asbestos, those are common in buildings of this age. So we'll be working with our abatement groups to ensure that we're properly accounting for those materials as well as we go through any future restorations inside of this building. Key preservation areas inside of this main courthouse that we are suggesting to the Texas Historical Commission are going to really be the full MEP upgrades to the facility, security, IT, AV upgrades for both of the courtrooms throughout this facility, as well as ensuring that all of the departments have all of the needs that they're meeting for their utilities. But then also just general upgrades throughout the facility for any maintenance needs that are ongoing. I know we had also discussed any needs that the elevator, I know it's kind of possibly going to be needing some improvements as well. And we'll be working with your maintenance teams as well for anything that they're seeing. Overall, we're grateful to have the opportunity to have both of these unique buildings on our local county square. That's a unique opportunity that you don't find in very many counties. And our goals through this master plan are to preserve them, not only for as the architecturally significant structures that they are, but to continue to provide them as the staples of our county government and our community services that they provide. So we appreciate the opportunity to be a part of this and would like to request permission to submit the master plan, updated master plan, to the Texas Historical Commission on Friday. Any questions?
Thank you. Any questions? So if there is no questions or discussion, we need a motion to approve the revised master plan for both courthouses and authorize submitting that to the THC by Friday.
I move to approve the revised and updated master plan for Gillespie County 1882 and 1939 courthouse and authorize submittal to the Texas Historic Commission for the Courthouse Restoration Grant Program.
Second.
All right, we have a motion and a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Thank you, Whitney.
Thank you.
Yeah, Whitney, thanks for all the work.
Appreciate it.
You have any special item you want to go to?
Mike here.
Mike just walked in. Mr. Land is probably, that will be a Mike thing as well. I don't see Mr. Land.
Yeah, I was going to submit it.
Oh, you just
Yeah,
submitted?
I did. Mhm.
So that we have time on there.
Okay. We're going to move to item 21, which is consider a variance request to county right-of-way regulations concerning the construction of 2 driveways on Chaparral Drive. Morning, Melissa.
Good morning. I sent a site plan with the driveways dimensioned, as well as the variance request through email yesterday. Would y'all like a handout of that as well?
Yes, ma'am.
If you have it
Yes,
available, please.
I do.
Thank you.
Thank you.
So Chaparral subdivision was platted in 1972 as a residential subdivision. Currently, there is a lot that is being developed on the corner of US 290 and Chaparral Drive. The lot was purchased, the house was demoed, and Now there's a wine tasting room being constructed there. The site plan that you have shows 2 driveways. One of them, based on, the scale drawing, the driveway to the north is about 31 feet from the edge of pavement of US 290. The second is about 164 foot from the edge of pavement of 290. Our right-of-way regulations require 200 foot spacing from a road intersection to a driveway. So this does not meet that criteria for either driveway. It also requires 100 feet between driveways and 50 foot from the driveway to the property line. The total frontage of this lot is 206 feet about. So obviously, a single driveway is not going to meet that 200-foot spacing. So with that in mind, I do see that it is reasonable to have a variance to the 200-foot spacing. However, I think that that should only be applicable to the driveway to the south at that 165-foot space, being that that is the farthest distance away from Highway 290. The development, as a commercial development instead of a residential development will generate more traffic than the single-family home did that was there before this. And it's just not safe, in my opinion, to have an additional driveway that's only 30 foot from the edge of pavement of Highway 290. The developer is requesting that driveway for bus traffic, so buses can turn off at 290 and pull in the driveway while people unload. But it's my opinion that this development is just not suitable for bus traffic. They should be utilizing the parking lot that's proposed in that south driveway to accommodate any future clientele that they would like to service.
So the variance is actually requesting the second driveway, right?
Yes.
It's several variances, the way I see it.
I only saw one variance submitted.
Yes, but
Right. The variance, we've been talking through the location of the south driveway. And I advised the developer that it was my opinion the north driveway wasn't safe, so they wanted to proceed with that variance request from the Commissioner's Court to, get that determination.
On the south one?
They're specifically talking about the north one, but yes, we would need a variance for the one to the south as well, since that does not meet the spacing. But that is, the driveway to the south is going to be the spot that most closely meets the intent of that ordinance, because this lot was developed before that spacing was put into place. So they should have access, but that access needs to be right.
Is there an existing driveway there?
There was an existing driveway about where the north driveway is that was serving the single-family residence, which was put in before we even had right-of-way regulations.
It was sort of like a cow trail off the road.
Do you have any other questions for Melissa? Is the applicant here?
Yes.
Okay. Do y'all want to present or make comments? Yes. Okay. All right. Come on up.
Yes, so based on the right-of-way regulations as well, there's that one driveway that there's Chaparral Drive. So with the change of residential to commercial, it is over 100 trips. So we would be looking at potential analysis of that intersection for improvements for public safety purposes.
Good morning.
Good morning. My name is Rarig Ross. I'm owner winemaker of Ferris and Fletch and partner owner of Chaparral Bin. I've been making wine for 17 years. I've worked with 8 different wineries. Our intention with this winery is to promote Texas grapes, Texas wine. Just a simple comment. Ms. Eckert is correct on the initial driveway that was there used by the previous owner, the residential site that is now commercial, to compensate for parking, organic traffic. We know buses will come. It's not if, it's when. Our concern is equally traffic safety, potential hazard, and yes, that initial entryway is pretty close to the highway, but I foresee buses trying to back out of the back lot and blocking potential traffic anyways, regardless of whether that is denied or not or accepted. I think our intention to bring that initial entry up to par and use that as a circle through would alleviate the stress that would happen if we were limited or restricted to just having that back lot. If you can imagine 3 buses pulling through there, incoming traffic. We don't want people parking on the side of the road, and I know a lot of the traffic coming from the east from Austin are going to be taking that turn lane, the median, and then turning in. I just don't want to see locals going out there making a right-hand turn and then them being in some sort of circumstance where we have this traffic jam. Having that access point, I personally believe will prevent a potential hazard. We don't want the liability of it, and so that's why we're here. But that is something that we are asking for you to grant. So, thank you.
Good morning, Commissioners, Judge. My name is Travis Jacko. I am the builder and part owner of this new tasting room coming in. I just wanted to do a quick clear up. On the site plan that you have, I think it says 36 feet from 290. I did a remeasurement. That site plan is wrong. The current driveway is 93 feet from 290 to the first edge of that driveway. So it's just a little bit of a miscalculation on that page. Yes, sir.
So you said your drawing is wrong, or the existing driveway is different distance?
On the drawing that you have, the measured feet is incorrect.
So it shows 30 feet off of 290. You're saying that is not right?
That's not right. Yes, sir. It's 93 feet from 290 to that first driveway. And all we're requesting today is the variance to use the existing driveway that's there and turn that into an entrance only. And then we were given the second driveway, which is further from 290, and that would be for main access into a parking lot. As Rarick stated, we do expect larger passenger vehicles to come through. We can't stop them. This proposed variance that allows the current driveway to be used as an entrance only will allow these larger passenger vehicles to get off of Chaparral Vin and to unload passengers in a safe manner. I'm also a fireman. I've been a fireman for almost 20 years. I've seen firsthand critical the importance of safe access points, especially off a 290 corridor. There's tourism, traffic. They can mix in unpredictable ways. I'm speaking today in support of the variance request for Chaparral Vin Winery to allow that existing driveway as an entrance only access under section 3.01 table -31 of our regulations. This is a modest adjustment from the 200-foot intersection setback, but one that can make a real difference in preventing emergencies before they happen. From my experience responding to incidents on busy roads, large vehicles like wine tour buses, limousines, pose unique challenges. Without a safe pull-off point, these buses could end up idling or maneuvering on the shoulder or on Chaparral Drive, blocking lanes and creating hazards for other drivers, cyclists, or pedestrians. This property is smaller than some of the other wineries along 290, which means it doesn't have the same space for standard configurations. But by granting this variance, we'd enable buses and larger passenger vehicles to quickly enter the property, getting them off the main roadway and allowing passengers to disembark safely without exposing them to oncoming traffic. Think about the risks we've all seen. A bus backing out onto a roadway could lead to a motor vehicle collision, or worse, a motor vehicle versus pedestrian. Exactly the kind of calls that tie up our fire and rescue teams, potentially delaying responses elsewhere. This entrance-only setup would promote smoother exits through the approved driveway, reducing those dangers and fostering orderly traffic flow in Chaparral Village. It's not just about convenience, it's about proactive safety measures that align with our shared goal of protecting public health and minimizing risk to everyone in the area. This variance represents only a minimal departure from our rules, and it complies with all other standards. Granting it won't harm development or safety. In fact, it enhances them by preventing the very accidents that could strain our emergency resources. As someone who's pulled people from wrecks and fought to keep our roads safe, I urge you to approve this request. It's a smart step toward a safer Gillespie County for residents, visitors, and responders alike.
With the addition of the second driveway, our impervious cover would be greater than 40%.
Yes, sir.
Retention, detention, issues there, is there a space to do anything with that?
We currently have an engineer who will be doing a complete drainage study on the property. This does enhance public safety. That's our number one goal. You know, this is going to cost quite a bit of money on our end to reconstruct the bar ditch, to add the culverts that are necessary, to add, to add whatever retention that we need to add, and we're willing to do all of that for this.
Can you talk about, it looks like there's like a driveway apron extending to the property line. Are you working on an agreement with your neighbor or something to have?
I think that's just the drawing itself. We actually back up to that section where you're seeing that. That actually backs up to Halter Ranch, their vineyard. So there is no access point into that area.
So the width of your property on Chaparral Drive is 206 feet?
Yes, sir.
So the math doesn't make sense to me. If you're 90 feet off the road, you got a 30-foot driveway, you're 50 foot off the property in the back, so now you got, that's 120, that's 170, you got another 30-foot entrance, that's 200 foot. So it's all entrance, besides the 50 and the 90.
So from 290 itself, it's 93 feet. There is the 290, the text dot bar ditch, which counts for probably about 20 feet. And then from that line, that's where our property starts. So really, from the property line, it's 50 feet from the bar ditch. But then you've got about 20 feet of bar, or 20, 30 feet of bar ditch or so before 290.
Is the regulation from the highway or from the right-of-way edge?
It's from the edge of pavement.
Edge pavement, okay.
We were speaking to an engineer, and as far as the construction of the driveway, the first driveway that is there currently is 20 foot wide. When we talked to the engineer, if we use it as an entrance only, we don't necessarily need it to be a 30-foot driveway because we're not asking for an exit point, it's just an entrance. The dovetail will allow for larger vehicles for them to turn in and that back tire to get onto that dovetail to get into the property. So we don't necessarily need a 30-foot driveway on the entrance. And that driveway does need to be reconstructed anyway. The two culverts that are in place that have been there for 35 years, they're completely crushed in, along with every culvert on Chaparral Drive. That whole bar ditch needs to be reconstructed.
So when you're saying a larger bus, I'm assuming 40, 45 feet?
No, we're looking for the bulk of the buses that are in town that operate on these wine tours are considered mini buses. They're roughly 30 feet.
So the bus really wouldn't be out of off of the state highway by the time they're starting to turn in. And you're saying the bulk. There are some that are longer.
There are, yes, sir.
My concern is we're going to have a tail sticking out there while they're trying to wiggle in.
Well, we have, from 290, I know what you're saying. And I drive a ladder truck in the city of San Antonio.
I drive big trucks, so I know what I'm talking
Yeah,
about.
and yes, I am very familiar with the tail whip scenario for sure. But it is 93 feet from 290 to the edge of that first driveway. So
How do you get that?
I know, and
I'm with Commissioner Weinheimer because this says 21 foot from the property line.
Yes, sir.
So you're saying 30 foot from the edge of 290, so
Yeah.
that's 50 feet.
I did a measurement. I measured it this morning before I came here just to be safe because I did realize that it did say 36 feet on there. So I know, I went straight to 290. I was out there at 7 a.m. this morning. I stuck right on the 290 edge.
So look at this. So this is incorrect?
Yeah, he's saying that 30.
I mean, and this, it doesn't say anything about,
I think I'm wondering if maybe like the edge of pavement of 290 that's shown on the site plan is not to scale or something like that.
So the edge of, so if we do the street edge of 290 to the first culvert was 93 feet. But their bar ditch, the TxDOT bar ditch accounts for probably 25 feet or so. But that's still from the edge of 290.
Yeah, so based on an aerial image that was pulled up, it looks like on the ground, it's about 90 feet. It's just the site plan. The
So
edge
that
of
would
pavement
be-
that's
that
provided
would
is
be
not
to the
correct.
start of the driveway.
Yes, sir.
Okay.
And so we have, I'm just trying to understand what the variance request is. There's an existing driveway there.
Yes, sir.
You want to continue to use that location? Is it being analyzed because of the change in use? So do you need a new permit for that? I guess, Melissa, that's a good question for you. And then the second ask is the additional driveway towards the south end of the property that
Well,
doesn't exist now?
In a sense, yes, sir. When we first started this project to do our development permit, we brought this to the engineer's office, and Melissa's been great. She brought up the rules and she said, I can't give you this first driveway, but with the development permit, we can move the driveway off of more further from 290. So we have the development permit for the driveway that you see there for the parking lot. The variance request hasn't been approved yet because we're still waiting on, I need to get drainage calculations for the bar ditch and the reconstruction of the bar ditch. So the variance request today is to be allowed to utilize the existing driveway that's there along with that second drive. And the variance really is for the existing driveway just to be used as an entrance only.
Okay.
Do you guys recognize the apps, like that are to show measurement? Can I show you something real quick?
I mean, we do, but I think we're going to need for me, I think for us to make a final decision, we're going to need it.
I think we need to update the site plan.
Yeah. I mean, I think we.
It's 30.2 meters from 290 to the first driveway.
And we are a long way away still from, well, not a long way away, but we still need to get all of our drainage calculations in order. And this is just one small step before we get all that done. But that is being in the works. We are working with Melissa's office to get those drainage reports in and the reconstruction of the bar ditch with the correct culverts, everything along those lines.
So how difficult would it be to get the site plan corrected?
It's not, sir. I just have to get with the engineer. We'll redraw that up and get the correct measurements. But that'll all be given to Melissa's office when we submit for the row permit.
No, you're great, thank you.
I think we're going to need an updated and corrected site plan, just because if we grant a variance, we want to have it tied to like an exhibit or something, so everybody understands what the variance
Yes, sir.
Is that was approved or granted. So any you have any other questions or discussion that we can get through today?
I think getting a corrected plan with the right information would be more appropriate.
Can you get that fairly quickly? I mean, we can put this on the next agenda if y'all can get it that quick.
I can get it, yes, sir, I can get it that quick.
I think it's just that,
Yeah, it's,
we've got these red, it's, like I said, if we want to approve it, we want to tie it to say this is what we're approving.
Yes, sir.
And have a clear understanding of what that is. So,
Okay.
Any other questions or discussion from the Commissioners Court? Anything else y'all want to present today? Any other discussion on this? I think we've already talked about it quite a bit, but.
No, I think that's it. So we're just needing a corrected site plan.
Well, I mean, my proposal would be that we take no action on this today. We'll put it on the next agenda in 2 weeks. And if y'all can get a corrected, site plan to us, and then we'll reconsider it in 2 weeks at the next meeting to pick it up, basically pick it up right where we are now and try to finish and get an answer.
Yes, sir.
We did contact TXDOT because that bar ditch was blocked, and I believe they've got to clean it out. So all the water that comes down this way east was just kind of pooled in one section in front, and so there will be some revision to that on there.
You're talking about on 290 or?
290's bar ditch. And as far as the traffic impact analysis as well with this property, I think the concern was traffic in and out, I guess the peak hour rate. And we did get an email from the engineering office on it. We did contact TxDOT as well. They didn't, they would require, or she was concerned, Melissa was concerned with the requirement of a turnoff lane or a deceleration lane. TxDOT can't do it because there's already a decel lane for Halter Ranch, which is within the 300 feet of our property. And then there's already a middle turn lane off of 290 as well. So vehicles traveling from the east will have a middle turn lane to get out of the lanes of traffic to turn into Chaparral Drive. And then vehicles coming from town have that lane to turn into Chaparral Drive as well for other vehicles to pass by.
Yeah, and I spoke to TxDOT after we talked about that a little bit, and essentially they did say that there wasn't enough room for a full turn lane, but recommended a tapered driveway, which is essentially a mini turn lane that's like 100 or 200 feet long and like 10 feet wide to allow traffic to at least get out of the main lane as they turn. But we'll, that's still, pretty early conversation about turn lanes, but TxDOT did recommend some kind of action there to help get people off of the main road.
TxDOT also said that an average short turn lane is about 300 feet. But that's what they approved over at Halter Ranch. Between Halter Ranch's driveway and Chaparral Village, I believe it's 300 feet. So that would be, I think less than 300 feet. So it would already be shorter than what TxDOT recommends. So the lady that I spoke with TxDOT recommended that close. I did not something at once because it's really not even a short turn lane. They recommend the actual dovetail. She was saying more than that. So,
Okay. If possible, if you're not intending to actually connect, that little driveway apron.
Just remove that?
You may want to remove that, because I think that
throws everyone
that's
off.
part of our consideration, I think, is if you have alternate routes or alternate, ingress and egress, and that looks like you could potentially have one there. So just for, if that's not your intention, I would, recommend that not be on there.
I think that's for if someone's backing out of the parking spot, they can back out.
Oh, is it? Okay, all right.
But I can remove that for you guys for the next meeting if you'd like.
Well, I mean, if it's so it's intended to be there as sort of a space for people to get out of those parking spots, I think is what Melissa's saying, which I could see the way that it's laid out. It looks maybe a little tight, so.
But not a throughway.
Right, okay.
Will the impervious study be
More than likely, no. That engineer is requiring probably like 3 to 4 weeks for the complete drainage study. And we were kind of waiting to see the commissioner's decision on this variance before we before we started the complete drainage study. Because if the variance is approved, then we are over the 40% coverage. If it's not approved, we're still at 39.6% impervious cover. However, we do plan on putting a stage, to have some live music for guests. So we do realize that adding anything like that, picnic tables on the ground, counts as pervious cover. And any kind of crushed granite walkways for guests to walk, that is included in pervious cover. So we will need a drainage study, and we do intend to do that.
I think the plan was to follow through with that after we do the decision here, so that we could have that coverage study done based on what we're actually going to have down on the ground.
Because if I do a study now, and it changes, I have to get another study. And as you know, those drainage studies cost anywhere between $5,000 and $10,000 for the study, that's not including the bar ditch, which I think was proposed at like $2,500 for the bar ditch regrading.
Where are you on the project? Any site work, or is this all conceptual right now, or is there actual work going on?
We are hopefully should be open for business mid-April, well planned. But if we're going to push this to the next meeting, then that means pushing opening probably till May.
Okay.
We're all closed up, the building's everything's pretty much done, that can be done on the inside.
Okay.
Was there ever consideration of maybe just a single drive, maybe a little larger, and doing the circle around?
I did look at that. I had Commissioner Yenschke there and a member from the engineering department. They did do a site visit. I did have a 18-passenger bus there, which is 30 feet long. And I can tell you, there's not enough room to do a circle drive with parking. And again, can that bus pull in and then back out, or?
That's not a good answer.
Right. And in my experience, I just.
It just looked like there was a lot of space back here that you could have maybe gone around the building.
Oh, I see what going around the building.
Correct.
There's not, no, sir. Not with the, there's a lot of trees on that property.
It's also a separate kids on that side.
Yeah.
Yeah, a lot of very large oak trees that we're trying to preserve, to not knock out. But yeah, the biggest thing obviously was public safety. Having it as an entrance only, not having those buses back out, just trying to prevent anything that we can.
How do you intend to keep it, entrance only, exit only? Just signage, I'm assuming? Or?
Signage, and, if need be, we can have an employee out there to direct traffic. I know a lot of these wineries, there are a lot of them have the signage up for entrance only or exit only. Am I going to be able to prevent everyone from not? And I know that was Mr. Yenschke's question as well. Can you prevent everyone from coming in and out? No, I can't. But I can do my best and try and do whatever we can to keep that as an entrance only.
Yeah, I think the layout of that driveway would also kind of force people to only be able to enter that way,
Yeah.
not to be able to exit. So they would basically put up some sort of barrier to where people would be able to do that.
Yeah.
If they really wanted to exit, they'd almost have to go back onto Chaparral, come back through, and go back onto Chaparral.
Mm-hmm. Okay.
And it'll be very apparent also.
Okay. Anything else y'all want to discuss today? Anybody want to put something on the record about delaying this for 2 weeks?
No action for go back on the agenda. Motion or special meeting, no action?
Yeah, I'll make a motion that that we take no action on this item today, and we will put it on the next Commissioners Court meeting agenda, which is March 24th, pending receipt of the revised and corrected site plan.
Second.
So motion and a second. Any other discussion? All in favor, say aye. Aye. Any opposed? All right, that motion carries. So you don't need to do a new form, but if you can just submit an updated site plan as basically an amendment to your application. And then, Melissa, can you put that back on, assuming it's ready? Okay. All right. Thank you, gentlemen. All right.
Thank you, gentlemen.
We're going all over the place.
Yeah.
Just for the record, on item number 15, we had a presentation and discussion, but there was no action. Which one do you want to do, 13? Let's go to item number 13, consider approval to pay Rush Truck Center. Michael?
Morning, Judge.
Good morning.
Good morning, Commissioners. I would like to ask the court to approve payment of $15,853.35 to Rush Body Shop in San Antonio for work which has been completed on Precinct 2's Western Star. The work's all complete, the truck's ready to go, and we're actually planning on picking it up on Friday. We can get drivers lined up to go pick it up. TAC has paid the county for the truck, so it's basically just a payment that we need.
You mean they paid, like insurance has?
Insurance has paid the county, yes.
That amount, that's $1,000.
Less than $1,000, well.
What's the total amount?
Total amount that's due is $15,853.35. And TAC did pay $15,120.10 is what TAC paid.
Well, I move we approve the payment to Rush Truck Center for repairs on Precinct 2 dump truck for an amount of $15,853.35.
We have a motion and a second. Any discussion? Where's this going to be paid out of? That's $1 million question, right? I'm sorry? Okay. You got it?
Yep.
Okay, all right. Any other discussion? All in favor, say aye.
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 Any opposed? Motion carries. While you're up there, let's do your other items. Sorry, Lindsay. Item number 20, consider approval of a proposal to complete construction of a canopy addition to an existing building at the county yard and approval to pay the invoice. We're having a demonstration. There you go.
I'd like to hand out a picture and
Okay, sure. Thank you.
I actually have an aerial photo there of where we're going to be putting the canopy on Precinct 1's building. It's outlined in green. And basically, what I'd like to ask the court is approve purchase of and payment of a 70 by 30 canopy to be added to Precinct 1's building in the county yard. The reason for doing it is because of the countywide equipment to store it when it's not in use. Like in the county equipment, you can always tell the ones that have been undercovered and ones that have been out, like in the sun all the time. It preserves the equipment quite a bit. It would be attached to Precinct 1's building. The canopy would come with the roof and two sides. The rear of it would be 30 foot, and the front facing 87 would be 70 foot long. And on the bottom of the canopy, there would be 12-inch, 100-foot curbing around, which would be 30 feet in the back, 70 feet on the side. That would actually be there to keep water and stuff from running through where the equipment would be stored. And I do have two quotes. I have one from DR Welding for $47,877.00. And then I have a second quote from Eiler Steel for $49,000. I would recommend DNR Welding to do the addition. They were the lowest quote, and they have done work in the past in the county yard. They actually built a mechanic shop, and last year they added on the awning to the front of the mechanic shop. They do great work, and they are the cheapest. And we did budget last year $50,000 in the budget, in line item 15,620, 5809 for this project. And this is the color of tin that we're planning on using. And the only reason why we're really using this is kind of a match. We have so many different colors out there. We've got green, we've got rust, we've got everything. It's kind of a neutral color. So this is the kind of color that we're planning on putting on the building.
Is the ground just going to remain dirt or unpaved, or?
Last year we went and we actually put pavement down.
Okay.
So we actually kind of started,
Okay.
yes, sir. We actually kind of started on the last year. We actually put pavement down. So it's not going to be, it's going to be a pavement like a parking lot.
Okay.
And the reason for two sides is it's going to butt up next to Precinct 1's building.
Yes, sir.
This is for countywide equipment to be stored in. It's going to be the rollers, the brooms.
Yes. Even the backhoe can be put under there. Of course, you got to work, the real boom you have to let down, but I think we can get that backhoe under there with no problem. It's 12-foot entrance up on top, so we should be able to get that under there too as well.
Anything else, commissioners?
No, I move we approve the proposal to complete construction on a canopy addition to the existing building at the county yard and award the bid to DR Welding in the amount of $47,877.
Second. What, sir?
Approve and pay.
Yeah.
Upon completion.
Approve and pay.
Who seconded?
I did.
Okay. All right, we have a motion and a second. Any other discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. Do you have anything else on this agenda?
No, sir. That's
Okay,
it.
thank you very much.
Thank you.
All right, we're going to go back to item number 7, start going in order. Item number 7 is approved job description or posting for positions in IT.
Good morning.
Good morning.
So this is the description for the technology director. It was edited at the end of September, approved in October, so there were no changes made to it. So we need to approve for posting.
I move we approve the job description and posting for the position of Information Technology Systems Director.
Second.
There's a motion and a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Item number 8, consider approval of promotions, transfers, payroll changes, and/or hiring for positions in the county sheriff's office.
Morning, gentlemen, ladies in the audience, gentlemen in the audience. So we are seeking the approval of the promotion of Correctional Officer Mark Serta, who is currently a jailer, to go from a jailer position to a patrol deputy position. He's been with the Gillespie County Sheriff's Office for 4 years at this time. His new hourly rate request will be $29.77. His patrol start date would be effective today, March the 10th. He has passed all the background check and as well as the psychological again and the
polygraph, and an aptitude/impulse test.
I'll move we approve. Second.
There's a motion and a second to approve. Any other discussion? All in favor, say aye.
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 Any opposed? That motion carries.
Thank you, gentlemen.
Thank you. Item number 9, consider approval of county clerk minutes for Commissioners Court meetings.
My request is to approve February 20th and 2020, and February 20th and February 24th, 2026.
I reviewed them and approved them.
I'll move we approve the county clerk minutes. Second.
There's a motion and a second to approve. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Item number 10, consider approval of a lease for T-hanger space at the county airport. Morning, Tony.
Yes, it is still morning, barely. I have a couple tenants that are moving into hangar Charlie 14, effective March 1st at a rate of $280 a month. The names are David Canese and Ronnie Crossland. They currently do not have an airplane, but they wanted to get a hangar before they bought the airplane. So they're looking around if you know anybody who has an airplane.
What's the term of that, Tony?
Indefinite. It is a auto renewal at the end of the year. So it's a 10, yeah.
I move we approve that. Second.
There's a motion and a second. Any other discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. Here you go, Tony. Thank you. Item number 11, consider approval of a line item transfer in the engineering department to transfer funds from 10596-4104 to line 10596-4103.
This is to, transfer the funds that were put in the account 596.4104 for part-time employees whenever we had the temporary part-time position open. That is closed now and was replaced with the full-time position. So I just want to move those funds back into 596.4103 for the current full-time employee.
So you moving the full amount?
Yes.
Yeah, I looked this morning, it's 14,250, does that sound right?
$14,250.94.
Okay.
I'll move we approve the line item transfer in the engineering department.
Second.
There's a motion and a second. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
All right, thank you.
Thank you. Item number 12, consider approval of an updated interlocal agreement between the county and LCRA. This is for radio equipment and services for the communications center.
Good morning.
Good morning.
I had received an email from LCRA advising that our current interlocal agreement that we had or have in place was last updated in 1999, so they're requesting that we update that. I did pass it along to Judge Jones, who I believe reviewed it and was good with it, so I'm just requesting approval to get that signed.
I'll move we approve the interlocal agreement between county and Lower Colorado River Authority.
Second.
There's a motion and a second to approve. Any discussion?
So you were good with it? the way-
I was good with the terms of it. Can you talk about like the compensation or rates and how it's going to affect, if any, on your?
I don't believe there's any, for this agreement, there's no rates or anything involved. It's just mainly for services. We have a separate contract for maintenance and things like that.
We have a motion, right?
In a second.
Any other discussion? All in favor, say aye.
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 Any opposed? Motion carries.
Thank you, Les.
Thank you.
Item number 16, receive a racial profiling report from the Gillespie County Sheriff's Office and acknowledge that the report has been filed with the Texas Commission on Law Enforcement.
Hold on a second. He's the one who did all the work, so I want to make sure he gets the recognition. And if you have any questions, he'll be glad to answer them. So it's just really about what we've already submitted to ACOG, and regarding racial profiling, he did 99.9% of the work. So if you have any questions, ask him.
Give us a rundown, sir.
We had 9,278 traffic stops last year, and out of those, we had 2 injuries that resulted from physical force, and that was to both subject and the officer. So we had 2 incidents where both got injured. We didn't have any other incidents where one got injured and the other didn't, so it was both at the same time. So that was fortunate. But other than that, when you look through the report, and it says, has a breakdown of all the traffic stops, contraband. There's so many categories, I don't really know what you would want to listen to.
Did we have any complaints of racial profiling, or?
No, we had 0 complaints.
0 complaints, yes, sir.
I move we receive the racial profiling report from the Gillespie County Sheriff's Office and acknowledge that said report has been filed with the Texas Commission on Law Enforcement.
Second.
There's a motion and a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. The report is contained in the Commissioners Court packet for today's meeting if anybody wants to look at it in more detail. Item number 17, consider acceptance of a donation to Gillespie County from the Gillespie County 100 Club to fund training for the benefit of the Sheriff's Office and authorize out-of-state travel for that training.
Everything should be in the packet. It's more of a broke down version for you guys to look at quickly. So the training that our CID division is looking at taking is an advanced training for their investigative work. I can't say enough of how blessed and proud I am of the CID division and what they've accomplished over this past year. This would just be an added educational purpose and an added tool to continue the direction of improving our investigative work through the Gillespie County Sheriff's Office. The total amount that we'd be asking for approval is $2,792.74, and anything that we would cover would be per diem and the travel, the vehicle travel, and all that is currently within our training budget for the Gillespie County Sheriff's Office. The course is actually being held in New Orleans. We told them that they were not allowed to have a lot of fun if they went, but we just want to make sure that it's approved and that we support the growth of our CID division.
I'll move we approve the acceptance of a donation to Gillespie County from the Gillespie 100 Club in the amount of $2,792.74 and approve the authorization of out-of-state travel for the 2 investigators.
Second.
There's a motion and a second. Any discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries.
Thank you, gentlemen.
Thank you, Sheriff. Item number 18, consider the acceptance of a donation to Gillespie County from Mark Land. That's for a water pump and associated hoses for the benefit of the countywide road and bridge.
Yeah, so the information's in the packet, but Mr. Land has donated a WT-30X Honda trash pump for water transfer and associated hoses and fittings. You can see that, it was in the packet. Anyway, this would fit with our new water truck we have in terms of being able to utilize it out in the county and support the fire in the event we need that. The approximate value of that donation is about $2,000. New equipment would be slightly in excess of that, but this is some used equipment, so.
I'll move to approve as presented.
Second.
So motion and a second. Any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries. Item number 19, consider approval of a policy requiring IT contract employees to complete fingerprint background checks and approve the payment of the cost for those checks. Les?
Good morning once again. Back in, I guess, recently, the IT department contracted with former IT director Roger Bunker for some IT work, I guess mainly just for the county in general. But that he could have access to our equipment, sheriff's office equipment, jail equipment. By CJIS rules, they have to be fingerprint background checked. He was as a county employee, but now that he's a contractor, we have to do that separately. So what I'm asking for is the approval to pay for those fingerprint background checks. It could extend beyond Roger. Since our IT department is kind of shorthanded, it could include other contractors if we get them approved and get them on board. I believe Weaver is currently one of those. I'm waiting on information from Weaver to determine how many of that personnel or those personnel may access our system. But by CJIS requirements, we're required to fingerprint them. So trying to figure out what we can do to make that happen so they can perform work on not just our equipment, but sheriff's office, jail, courts, anything to do with Odyssey, things like that.
Do they also need to take a CJIS training? To be able
Yes,
to
they have
access
to have the CJIS security awareness training. There's no cost to that, but they would be required to do that too. And Roger has already completed that.
What's the cost on the fingerprint background check?
They're $10 per submission plus $1 administrative fee, so $11 total. And that's per submission.
Yeah, so it says approval of policy. So is there a policy right now?
We
or
don't
we're
have
just-
one now that I'm
so
aware of.
We're just establishing that we can go forward.
We probably need to come up with one and then,
I think the discussion is, do we want to require that? And then if we do, are we going to allow, I mean, I think Les buys like a bulk, like, do you buy the fingerprint credits, I guess, in bulk?
yeah,
or-
so I obtained fingerprint codes from the company, and we only pay for those as we utilize the code, so $11 per submission. They provide us with a list of like 50 that expires so often, but we only pay for those if we use them.
So I think the second part of the question was, is Les okay to pay for this service, basically?
How would we consider approval? How would I make that into a motion? I'd be glad to.
Well, it's not going to be a written policy. I think it's just going to be a
Approval.
sort of, an internal policy.
Yeah, in the past, all these contractors pretty much have been escorted when they're working on the system. With IT being as short as they are, there's a possibility that could not be the case. So they have to be background checked, just in case that does happen. With Roger, pretty much comfortable with doing that since he is the former IT director. But he will most likely be escorted as well, but just in case that doesn't happen.
I'll make a motion that we require any IT contract employees to complete a fingerprint background check and complete the CJIS training prior to conducting any work on county assets, and authorize payment of those costs by the county.
Second.
All right, we have a motion and a second. Any discussion? My question is this, do we need to limit it just to people that access CJIS? I mean,
So again, CJIS could be anything with Odyssey, could be anything with the courts, sheriff's office, jail. So, I would assume they would have access to other systems too that may not meet CJIS, but so I think it would include not just that.
okay. I think my motion would cover any IT contract employee regardless. So I guess if there's an issue with somebody that doesn't need CJIS, we can discuss it at that time. All right, any other discussion? All in favor, say aye.
Aye.
Any opposed? Motion carries.
Thank you.
Thank you, Les.
Thank you.
Item 22, consider approval of the appraisal report for artwork and approve payment of the invoice for the services rendered. I don't know, are we going to pass on the first part of that today?
We're going to pass on the first part. The Library Advisory Board has not looked at the report in their part of the party that requested it. So I would like to move that we approve payment of the invoice to Leanne Watley in the amount of $4,800 for the appraisal of the artwork in the library.
So we have a motion and a second to approve the payment. What was the amount? 4,800?
So I assume we've received the appraisal?
The appraisal is complete. I said the Library Advisory Board has not looked at it. I have not looked at the full extent of it.
We just received it a few days ago, so
Okay.
I think, well,
That was just my question. We've received the
right,
appraisal?
yes.
Okay.
I think for us to have a meaningful discussion on it, we needed to have more time to review the actual report. But plus, the Library Advisory Board wants to review it as well. So we have a motion and a second to approve the payment. Any other discussion? All in favor, say aye.
Aye.
Any opposed? That motion carries. There'll be no action on the approval of the appraisal report today. We will discuss that at the next meeting. All right, item number 23 is an executive session item. We've got several matters to discuss. And we had two individuals that signed up to speak. I don't have the sheets. I think one was Mr. Knightsky.
I have some questions for Ms. Schneider. She could not be here. She just wanted me to read off a couple of questions and a small statement about this issue. She had an appointment that she had to be at. I just wanted to use the rest of her time to bring those questions to you.
You think okay with that? Okay. All right, you want to go first, Mr. Strange?
Excuse me?
You're going to go first, Mr. Strange?
Yes, sir.
Okay.
This is according to, going back to the B, subject B in the executive session. And she's asking, is the reason that the vendor is suing the county for payment because it was an illegal non-bid contract? From our understanding, all of these bids have to have competing bids, and this was the only bid, and it was accepted. The second question, according to the audio, is it true that all 5 of you voted to approve the illegal bid in October? And again, I'm the messenger, don't throw stones. And then the final statement, you approved the agenda to include all 3 of these items in March 4th, the day after the election. Once again, there's a serious lack of transparency, and this is why we are recording these meetings. Thank you.
Could you restate that last one? Scott, I didn't get the last statement.
Repeat the last question.
Yeah, or last question.
You approved the agenda to include all 4 of these items on March 4th, the day after the election.
I don't know what items you're referring to.
The contracts. I'm assuming that's what she's talking about.
4 items. Okay.
Okay?
Mr. Knightsky?
Yes, so I have just 2 items on this. So number one, I would remind you of my earlier comments about the fire code, that and to just expand on that. We were talking about a delay and timing. The documents that have been requested supposedly have already existed for 2 years. So in any leeway time, I my opinion has already been granted. So I don't think we need to convey any more time to them. And then secondly, on the county engineer issued also a violation saying, please respond within 5 business days from December 5th. And she indicated that she hadn't received anything yet either. She has fines limited but not more than $500 for each violation per day. So there are also fines that she had put in there.
Thank you, Mr. Knightsky. All right, Commissioners, anything before we go into executive session?
No, sir, not at the moment.
All right, so for item number 23, the court, we're going to recess our open meeting and reconvene in executive session pursuant to 551.071. For the items listed on the agenda, A is the county's interest concerning Rogers Draw and the Marshall Springs Solar Complex and Battery Energy Storage Facilities. Item B is the county's interest concerning a vendor payment claim, and item C is a pending lawsuit against the county related to automobile accident. It is, let me get a timestamp real quick. It is 11:43 a.m. We're going to recess the open meeting and go into executive session. I don't know if there's some in there.